you should expect a consular process through marriage to take like 2 years, probably minimum right now. And that might dramatically increase as the Trump administration reduces the resources available to the Department of State. If you're thinking about bringing a fiance or a spouse over to the United States and you want to petition for them, whether you're a US citizen or a permanent resident, then this video is for you if you're looking for a good place to get started learning about the process. For those of you who don't know, my name is Puyan Darian. I'm an immigration attorney with an office in New York, but I practice these cases nationwide. And I like to focus my practice on family-based immigration and specifically spouse-based petitions. So the first thing to know is that you can petition for someone as a fiance. You don't need to necessarily be married, but the chances of it getting denied are probably higher if you're just petitioning for them as a fiance. And you must be a US citizen. You cannot be a permanent resident if you're filing a fiance petition. Now, if finances are a concern and you're trying to save money on like the total process, you're not just concerned with like timeline and stuff like that, or where you get married or when you get married, then I wouldn't do the fiance petition. I would probably get married abroad, or if you've seen my other videos, you can go to the Utah state website and get married by video. Even if neither spouse lives in Utah, you can get married by literally a Zoom meeting and get a legit marriage certificate from the state of Utah that's accepted by USCIS. A lot of people saw the old video I did on this topic and have gotten Utah marriages, and a bunch of those people are now permanent residents after they hired us to do their cases. So, kudos to those people. If the timeline for getting married is complicated, like for example, your spouse lives in a country that requires that both spouses be residents of that country to get a marriage license, then the Utah-based option might be a good option, or a fiancé petition might be a good option. But what I was trying to say before is actually that fiancé petition is going to be a multi-step process. First, you need to apply for the fiancé visa, which has costs and takes time. The time is a constant. Like if you're petitioning for a fiancé or a spouse who's abroad, those are both going to take a while. After the fiancé enters the US, they now need to marry you and apply for adjustment of status, which is going to be another expensive process, and it's still going to take more time. Whereas if you got married abroad and then you petitioned for your spouse to come over, the moment they entered the US, they're entering with an immigrant visa, which means they become a permanent resident on the day they physically enter the United States. And that could save a bunch of costs down the road. If the marriage is more than 2 years old, by the time they enter the United States, they're going to get a 10-year unrestricted, unconditional green card. And then the only thing left for them to do is naturalize, which they can do as early as 2 years and 9 months later after they enter the US, if they meet all the other requirements for naturalization. The biggest question I get is something like this. So I have a spouse who resides abroad. They have a tourist visa, or they have a student visa, or an H-1B visa, and they keep traveling in and out of the US. Should I file an I-130 petition for them to consular process and go to a consulate interview abroad? Or should they apply for adjustment of status in the US? And the answer is somewhat complicated, and I'll try to spend a few minutes talking about some of the considerations here. If you file an I-130 family petition based on marriage for someone who has a non-immigrant visa, like a tourist visa or a student visa, when they enter the United States, the customs officers will see that they have a US citizen spouse with an I-130 pending, and the immigrant spouse will likely be heavily questioned about the intent of their entry into the US. The customs officer wants to see, are they just coming here to visit? Or are they coming here to apply for adjustment of status, which is inconsistent with allowing them to enter as a tourist? Because when you enter as a tourist, you must have the intent to depart the United States. Same thing with a student visa, which is a non-immigrant visa. When you enter as a student, you must maintain the intention to leave the US at the moment you're entering. You must have that non-immigrant intent. If the customs officer doesn't believe that you have non-immigrant intent, it could be a nightmare scenario in the airport, and you can end up getting your visa canceled. There could theoretically be a fraud determination, and you would be kicked out of the United States at that point. And then we have to deal with the aftermath of that depending on whether or not a fraud determination was made, will likely determine what the next steps are there. Another thing to consider when you're filing an I-130 and the plan is to consular process is processing times. So you should expect a consular process through marriage to take like 2 years, probably minimum right now, and that might dramatically increase as the Trump administration reduces the resources available to the Department of State, which is in charge of the consular offices, straight up closes some consulate offices, reduces the staff and resources of the consulate offices. This is all going to result in longer processing times when you're waiting for your interview at a consulate abroad. Generally speaking, you should expect the family petition portion of the I-130 when you're trying to consular process to take like a year to a year and a half. Let's call it a year and a half for purposes of this video. You could try to speed it up sometimes by simultaneously filing a K3 visa, which has no government filing fee, but you have to submit the paper version of the form. You can't submit it electronically, and that might sometimes speed up the I-130 processing times. I'm not going to go through the mechanism by which that takes place in this video. I've done other videos on that, but just, take it as true. It can sometimes speed up the I-130 processing times. After the I-130 gets approved, the case will be transferred to the National Visa Center. And that could take like 6 weeks just to transfer. And then it'll probably be pending there for anywhere from like 1 to 5 months. I would say the average is like 3 months, assuming you do everything correctly as soon as possible. Then it'll get transferred to the consulate. And this is where the country matters. Like, for example, if you're trying to wait for a consular interview in Bangladesh, people who were waiting in 2021 are still waiting. And it's been like more than 4 years since the case was documentarily qualified at the National Visa Center. Whereas, India is probably like 6 to 8 months right now for them to schedule the interview. The UK might just be a few weeks. It depends on the country. And unfortunately, I think like third world countries are going to see the more dramatic reductions in staffing at these consulates, which is probably by design to reduce the number of people entering the US from third world countries, which is pretty on point with the Trump administration's general plan to reduce legal immigration as well. But let's say, for example, your fiance or spouse enters the US and there's no I-130 pending. When they're going through customs, the customs officer asks them what you want to do, and you indicate like, I'm going to visit family, I'm going to visit friends, going on a tour throughout the United States. And these are all true. You are visiting family, you are visiting friends, you're going on a tour throughout the United States. The officer asks no additional questions. You make no misrepresentations whatsoever. And then let's say you've been in the US on your tourist visa. 3 months later, your boyfriend or girlfriend or whatever, significant other, proposes, and you guys decide you want to get married. And now you're trying to figure out, should we file an I-130 and do it through the consulate abroad, or should we consider applying for adjustment of status in the United States? Generally speaking, as long as you entered without fraudulent intent, you entered with non-immigrant intent, and there's no other major issues with your case, like criminal history, which is probably not an issue if you've only been in the US for like 3 or 4 months, or prior fraud or any other bars to adjustment of status, like you entered as a crew member or on a J1 visa with a 2-year residency requirement. As long as you have a clean case, I would almost always choose adjustment of status in this situation. But there's one main caveat. Once you apply for adjustment of status, you should forget about trying to travel on advance parole, which means the moment you submit the adjustment of status application, you no longer have a valid non-immigrant visa. You can no longer travel back and forth as a tourist or on your F1. If it's an H1B visa or a dual intent visa, that's an exception. You can validly maintain that visa while your adjustment of status is pending and still travel on it. I would still try to limit your travel when you have an adjustment of status application pending. And the reason for that is because if we apply for advanced parole, your re-entry into the US, even if advanced parole is granted, is not guaranteed. The customs officer has discretion to deny your re-entry, and it's a massive risk to take, especially since you're not going to be able to re-enter on a tourist visa or other non-immigrant visa after you've applied for adjustment of status and shown USCIS that you have immigrant intent, the intent to permanently live in the United States. So in this hypothetical scenario, if the immigrant spouse is able to stay in the US for the entire adjustment of status process, from when we file it until they get the green card physically in their hand, then I would almost always choose adjustment of status in this situation. It's faster, you have a right to an attorney the entire time, you guys can start your lives together sooner, you don't need to deal with a long separation where the processing times are really uncertain and changing and getting longer regularly. The immigrant spouse can be eligible for employment authorization if the processing times take longer than 3 or 4 months. You'll probably get a work permit and social security card while your case is pending, which just helps you guys, begin your lives together sooner. So a bunch of benefits, and I have a strong preference for this option when you are a good candidate for adjustment of status. All right, guys, so if you saw this video and you have a bunch of questions, you could always schedule a consultation directly with me. The booking link is in the video description below, or you can just go to my website, darianlaw.com, and book a consultation directly through there, or give my office a call. For those of you who are new to my channel, I focus on family-based immigration and naturalization, and I do a lot of videos lately on changes to immigration policy and law under the Trump administration. If you want to stay up to date on all the changes that are taking place, or just see it from like an immigration attorney's point of view, be sure to subscribe. I put out a few videos each week, and I'll see you guys next week for another video.